David. Please step to the podium, sir. We now have 15 CRA 4911, the State of Ohio, the City of Palm versus Logan, Daniel Sinclair. Mr. Sinclair has been in custody at jail since yesterday evening. He has been in custodial fashion since Saturday the 28th. Mr. Tates has been appointed as public defender to represent him. I'm Judge Spanigaloglu.
Pause for a second. This isn't just murder. Aggravated murder is the most serious charge under Ohio law. The word aggravated means the state is alleging extra circumstances, here a killing tied to an armed robbery and flight from the scene. Translation, this case instantly jumps into life sentence territory and potentially even death penalty eligibility if prosecutors later add the right specifications. And notice something important. This is an arraignment, not a trial. No evidence argued yet, just the formal moment where the court lays out how serious this really is.
You've been charged with the crime of aggravated murder, a felony of the first degree. This is what is called the arraignment. The purpose of the arraignment is to explain to you the charges against you, the penalties you face, and the procedures that you have to follow and the rights that you have. I have given your attorney a copy of the complaint. It is alleged that on Saturday, while in Parma-County, Ohio, that you did purposely cause the death of Robert J. Sposett while fleeing immediately after committing the offense of aggravated robbery, this being at the Sunoco gas station at 5385 Thoreau Road. As charged, that is aggravated murder, a felony of the first degree. If you are convicted, you will face a potential fine of $25,000 with no minimum mandatory fine. You will face life imprisonment. There is the possibility, although not noted at this time, that if certain specifications are added to the criminal charge of aggravated murder, you could potentially be subject to the death penalty. That does not exist at this time. That would be a matter for the county prosecutor. You may face additional charges. Additional charges including gun specification or aggravated robbery here, as they have alleged. Those are also matters that may come up later. You have the right of silence in front of me. All proceedings are recorded so that anything you say may be used against you. You have the right to an attorney. You have qualified for Mr. Tates at this stage as your public defender. You may have a future public defender at other stages of the proceedings, as Mr. Tates is for these proceedings only. The arraignment that I'm doing now is the first step. That will include the setting of bond. The next step is what is called a preliminary hearing. The purpose of a preliminary hearing is to give you an opportunity to confront the evidence against you as to whether there should be a charge going forward or not. At that hearing, you would be here with Mr. Tates, the prosecutor Parma would be here, but then would be a hearing in front of me. This hearing is not a trial. It is not a proceeding to find you guilty or innocent, but in order for the felony to proceed, prosecutor...
This part right here trips a lot of people up. The judge is not deciding guilt, only whether there's probable cause. That's a much lower bar than beyond a reasonable doubt. Think of it like this. The court is asking, is this accusation strong enough to move forward? Not, did he definitely do it? And here's the strategic twist. By waiving the preliminary hearing, the defense avoids showing their hand early, but also gives the prosecution a direct runway to the grand jury.
Show me enough evidence to establish two things of probable cause, or to better explain that two things are probably true. First, probably true that someone caused the death of Mr. Sposett. Second, probably true that you are that person. If I find those two things to be probably true, your case then goes to the common police court for further action. If I did not find those two things to be probably true, I might dismiss the case. It is also subject to direct indictment, where the police at any time can ask the grand jury for an indictment. If the case does go downtown, however it may go downtown, you would go to another arraignment similar to what I'm doing now. And at that arraignment downtown, you would enter a plea of not guilty. You do not say not guilty at this stage. You'll have a new public defender appointed for you. If that case is resolved in some way prior to a trial, fine. But if it is not resolved prior to a trial, it would automatically go to a jury trial, where it's the job of the county prosecutor to prove beyond a reasonable doubt that you are guilty of either aggravated murder or a lesser included offense. If you would rather have a judge decide the case, you could do that. That's called waiving the jury. That's a decision that you would make once you see the evidence downtown and consult with your attorney. Do you understand what I've explained thus far, sir?
Yes, Your Honor.
Any questions?
No, Your Honor.
We will let the record reflect the defendant understands the explanation of rights. Now, you have discussed the case with Mr. Tate in our lockup. I have what appears to be your signature on a waiver of preliminary form. To indicate you can also waive that hearing I explained. Let me show it to you. Did you read the form, sir, before you might have signed it?
Yes, Your Honor.
And did you then sign the form after you read it?
Yes, Your Honor.
Now, by signing this form, you are not waiving any rights that you have as a defendant in this case, except the preliminary hearing that would have been held now will not be held. Means that your case will go forward to the grand jury for indictment. Once that indictment is issued, you will go to that arraignment that I explained to you downtown. You'll then get your new attorney down there, and at that time you would enter a non-guilty plea. Now, even though this is a preliminary stage, have you had enough time to discuss this case with Mr. Tate so he understands what it's about and he's been able to give you good advice?
Yes, sir.
Okay. Right now, are you under the influence of any alcohol, drugs, or medications, whether prescription or non-prescription?
Yes.
And what are you currently taking, sir?
Oxycodone.
Okay, is that relative to your injuries?
Yes, sir.
Okay. But you're mentally clear right now? You understand what's going on? Say it out loud.
Yes, sir.
Thank you. I am satisfied that Mr. Sinclair has made a knowing, intelligent, and voluntary plea, waiver of preliminary hearing rights, with effective assistance of counsel. Although bond still to be determined, court will order that 15-8-49-11 be bound over to the grand jury for further proceedings. As to the matter of bond, Mr. Sinclair, we now must get information relative to the determination of bond. Your PD form indicates you live with a girlfriend, you're unemployed. Are you currently out on bond for any other criminal or traffic charges?
No, Your Honor.
Are you currently on probation, parole, community control, or post-release control for any
No, Your
charges?
Honor.
To the best of your knowledge, are there any other pending criminal or traffic charges pending anywhere against you?
No, Your Honor.
Okay. Court notes his record appears to indicate he has no prior common police history in our county. Leads apparently indicates an arrest about a year ago out of Cleveland, but does not show any disposition. Mr. Dovick, does the city wish to be heard as to the matter of bond?
We do, Your Honor. The city is asking for a $5 million bond. We believe that the defendant is a flight risk and a threat to the public for the following reasons. He was involved not only in the armed robbery, such as killing of Mr. Spossett, but he also shot at a witness that particular evening, a witness that was giving assistance to Mr. Spossett. And in addition to that, about an hour before, he was involved in and committed another armed robbery in the city of Cleveland. I've had an opportunity to speak with the lead detective on this case, Detective Wells, and accordingly the city has asked for a $5 million bond.
Okay. So this other incident, Cleveland's investigating, but they're obviously liaisoning with Wells?
They are, that's correct, Your
Okay.
Honor.
All right. Mr. Tate, you may also be heard as to the matter of bond.
Your Honor, we're aware, I talked to my client, the seriousness of the charges being brought against him, and the only thing I can say, Your Honor, right now is the lack of any significant criminal record, no felony record for my client.
Although it may be unlikely that you may be out of jail, Mr. Sinclair, given the nature of the charges, I'm going to place some non-monetary restrictions before we get to the monetaries. If you were to get out of custody, you are to maintain your current residence. If you must move, it must remain within Cuyahoga County. You would have to notify the court, and Detective Wells, the lead detective in this case, of your address. You are not to have any contact with the decedent's family. So you're not to have any contact with Robert Spozzett's family. Should you be out of jail, your area of travel will be limited to Cuyahoga County, which means you could not leave the county without permission. Now, the court will impose a cash surety bond. Mr. Dovick, there's been intimations by the county prosecutor that we set excessively high bonds. I understand the concerns, but I think $5 million for the sake of maybe excessive. I'm going to set a...
This is the moment everyone waits for, and the number tells a story. The prosecution asked for $5 million, arguing flight risk, public danger, and another armed robbery an hour earlier. The judge pushes back, not because the case is weak, but because courts are legally required to avoid excessive bond. So $3 million becomes the compromise. But let's be real. A cash or surety bond at that level is effectively a detention order for most defendants. Legally allowed, practically unreachable.
$3 million bond, which I still think is sufficient. If Mr. McGinty wishes to seek an addition to that. We will deal with that through Mr. McGinney when the case gets downtown. Which means hypothetically for a $3 million cash or surety bond, given the nature of it and the potential of the death penalty spec, hypothetically you may have access to contact to see about bondsman or whatever to post that bond. And if you have a jail credit, let's see. Jeff, approximately what time was he custodialized on Saturday night?
Somewhere between, right around midnight, between 11 and midnight.
Okay. For the record, I have to give you a jail credit, sir. You have a 4-day jail credit toward any potential sentencing. Mr. Dobick, anything else as to Mr. Sinclair?
Not on behalf of the city, Your Honor.
Okay, Mr. Tate, anything else?
No, Your Honor.
Close proceedings as to Mr. Sinclair. You may take Mr. Sinclair back downstairs. We'll have them prepare the appropriate MIT papers. Michael, would you take the, have them send that downstairs so we can get the